Hey guys, welcome back to today's video. I'd be covering the jury trial of the last sovereign citizen morons. Unfortunately, despite earlier claims that it would be streamed, the trial never went live. But honestly, that turned out to be a blessing in disguise because today's backup is even crazier. We've got not one, but two absolute courtroom disasters to break down, one from Florida and another from Washington. The first might be one of the most clueless people I've ever covered on this channel, and somehow the second manages to be even worse. Trust me, this one only gets more ridiculous from here, so let's get into it.
I would have one of those. I don't seem to have. I hid it for myself and Mr. Gonzalez. You ordered to stay away from 150.
Judge, he's not. I apologize for interrupting. He's no longer there. Corrections took him away.
Okay.
Utilize my right to be heard, and I'm representing myself, Your Honor. I just got back from the last courtroom where I was RR'd. Are you ready to hear what I have to say, Your Honor?
I am.
All right, cool. So I would like to inform you, Your Honor, that there is two open lawsuits. One against this court system for wrongfully finding probable cause on police misconduct and violating my 6th and 14th Amendment and due process, which led to false imprisonment. Against the Miami Beach Police Department for multiple false arrests where they have violated my constitutional rights and multiple United States laws. This situation is very serious, Your Honor, because I now have to file another lawsuit for attempted murder and attempted vehicle manslaughter. I say vehicle manslaughter because these two police officers that followed and stopped me November 6th is the same two police officers that watched me park my bike on 10th and Ocean, pace back and forth next to my bike on 10th and Ocean, and then hit me off my bike while they ran onto the sidewalk, also hitting two other pedestrians. So that was vehicle manslaughter.
Vehicular manslaughter, you say? Well, I hate to ruin your little jail-issued breakfast, but manslaughter of any kind requires an actual deceased victim. And while your brain cells may have flatlined long ago, you unfortunately seem to still be breathing. So, unless stupidity suddenly became a fatal condition, I'd say your argument just crashed harder than your case did.
They never tried to attempt to pull me over. Like the A foreman said, they tried to, that I tried to evade them. They tried to pull me over. Because if I tried to run away, why did I park my bike? And you see me park my bike on 10th Street. So look, let me continue. There's another one that I have to file for attempted murder because when they said, put your hands behind your back, they prevented my hands from going behind my back while covering my face and mouth. That is attempted murder. So now let me start. November 6th, right? And I've had this bike since February. November 6th, these officers witnessed me talking to 3 girls or whatever. They followed me for 3 blocks and then took the same right turn that I took. And then I made a U-turn onto the sidewalk and then they stopped following me. Then they approached me when I was talking to my friend on a bike lane on Ocean Drive between 11th and 10th Street. That is when they wrote the ticket. And they said, if I don't walk my bike home, my electrical bicycle, then I'll be arrested. So I walked my bike home and then went back to the same officer, Officer Rivera, after I did my research. And I told him that because my bicycle has pedals, it is considered an electrical bicycle. So if you try to arrest me for riding my electrical bicycle, I will file another lawsuit against you. And then I rode my bicycle November 6th and no one said anything. I rode my bicycle November 7th. No one said anything. I've had this bike since February 8th. I've got pulled over for running a red light. I even called the sergeant. The regular officer and the sergeant never said my bike was not street legal. This was March. This was July where I got pulled over again. I requested the sergeant, the regular sergeant, and the regular officer and the sergeant never said that my bike was not street legal at all. So what I'm saying is, to you have a judicial code of conduct. You have to follow the law at all times. It's your duty to follow the law. And based on the 14th Amendment, I have the right to be treated equally. So if they're not arresting DoorDash drivers, Uber Eats drivers for riding their electrical bicycle, you cannot keep me in jail for riding my electrical bicycle. This is what I explained to the judge previously, and I got RR. And the public defender had did their research. They found out that with pedals, it's still considered an electrical bicycle. And I even informed this officer, and he even seen me riding southbound. He made eye contact with me on November 8th on Saturday. He made eye contact with me while I was driving southbound on Ocean Drive. If I was riding something illegal, right? If I didn't go back up to him and tell him that if he tries to arrest me for riding my electrical bicycle, he will be sued. Why didn't he just pull me over? If what he said that happened on 9th Street, why didn't he pull me over? Why didn't he on his golf cart and pull me over? He did no such thing because that is a lie. He lied on the A form, and I'm proving it to you because I parked my bike down this 1 block away. So if I really tried to run away from the police, why did I park my bike 1 block away? And based on the fruit of the poisonous tree doctrine, anything that rooted from illegal activity cannot be used against me in the court of law.
Well, that's not actually how the fruit of the poisonous tree doctrine works, as established in Wong Sun versus United States. The doctrine applies when evidence or confessions are obtained illegally, allowing the defense to file a motion to suppress that specific evidence. It's not some magical get out of jail free card that instantly makes the entire case disappear. And honestly, your argument falls apart even faster when your own story keeps changing. First, you claim the police knocked you off your bike, now suddenly the bike was sitting a block away. Before you start throwing around constitutional buzzwords, you might want to figure out which version of events you're actually sticking with.
So all the charges has to be dismissed. From riding with a suspended license, I don't need a license to ride my electrical bicycle. Vehicle registration, I do not have to register my electrical bicycle. And driving with a license suspended, I don't need to have a valid driver's license to ride my electrical bicycle. And this all...
Judge, on his traffic case, he received R.
Well, good. Anyway.
Yes, so what I'd like to say is that also Burger King is across the street from the police department. So no police officer can say that they don't see other electrical bicycles and other dirt bikes riding on the beach. So it's no excuse, not even just pouring it out that they lied on the A form. And it's all the workers. I even have a video. There was electrical bicycles passing by November 6th as they was writing me a ticket for my electrical bicycle, which was a blatant violation of my 14th Amendment. So they continue to write a ticket for my electrical bicycle as someone pulled over and said, "What's going on?" A restaurant worker that usually parks their electrical bicycle right there on Ocean Drive. You cannot be a police officer and say you don't see electrical dirt bikes riding on the Drive and electrical bicycles riding on Ocean Drive, because there's 15-year-olds with electrical dirt bikes since last year that has been riding up and down Ocean Drive, and no one has said anything to them. So it would be a blatant violation to arrest me or harass me for riding my bike. So I would like to be involved with this as well, because I'm not sure why it was divided into 2 judges at all. And the public defender already looked at the law. If you want to look at the law, based on the fact that my bike has pedals, is considered an electrical bicycle.
All right then. So it sounds to me like you've already raised a misdemeanor, Judge, about your pedals and your electric bicycle. I myself am dealing with 4 counts of battery on a law enforcement officer, 1 count of resisting an officer without offering to do violence, 1 count of felony marijuana possession, and 1 misdemeanor arresting. So those are the cases I'm dealing with.
Yeah.
Not that whether or not your bike has pedals on it.
I'd like to include, Your Honor, that my older brother passed away because someone hit him off his motorcycle 2016. I would never run away from the police.
Uh-huh.
And the fact that they waited till I hopped on my bike to try to hit me, to try to build a false narrative like I was evading them, is completely illegal. They waited till I hopped back on my bike after seeing me hop off my bike. So that is what? Vehicle manslaughter.
Once again, you are very much alive, loud, argumentative, and somehow still convinced you were manslaughtered. Last time I checked, manslaughter requires an actual death, not just an unbearable personality. So no, I don't think anyone killed you, but thankfully the judge is about to step in and give her own perspective on this circus, and judging by the look on her face, she's already running out of patience.
So now I have to file another...
It would only be vehicle manslaughter if you were dead, but you are quite chatty for a dead person. So I really can't find that you're dead.
Why did they attempt to murder me? They covered.
Ah, well, that's a horse of a different color. So what I have to deal with was what's written on the arrest affidavit, not your constitutional arguments, which may very well be filed in a different court on a different day. I have to deal with the four corners of the document there.
Yes, based on the four corners of it.
Based on the corners of the document, I'm going to find probable cause on counts 1, 2, 3, 4, 5, 6. And let me ask corrections. Was the resisting without violence dealt with in misdemeanor court or not? What?
I would like to, Your Honor,
Stop! I'm trying to get an answer from corrections as to whether or not the resisting without violence was managed misdemeanor court or not.
Your Honor, if I have to pay any type of bond, then I will file another lawsuit against this court system.
Well, alrighty then. You feel free to do so. Probable cause is found on counts 1, 2, 3,
and the fruit of the poisonous tree doctrine. That rooted from illegal activity, it cannot be used against me in a court of law.
Well, that yes, it's the constitutional background for a motion to suppress evidence that was seized. I read that case once. So counts 1 through 4, the bond is $2,000. Count 5, the bond is just $1,000. Count 6, the bond is $1,000. Count 7 is an ROR.
Judge Victoria Singular.
I am Judge Victoria Singular.
Not ROR.
All right.
I will file a tort.
Please feel free to file whatever things you think are appropriate.
I always get a good laugh when a defendant thinks threatening to sue the court is somehow going to help their situation. Spoiler alert, it never does. If anything, it just convinces everyone in the courtroom that you have absolutely no idea how the legal system works. But now, we're leaving Florida behind and heading over to Bellingham, where we may have found someone even more unbearable than the first guy, and trust me, that's an impressively high bar to clear.
This is case number 5A08688584. I did review the report that was completed and filed by DSHS. And does the city want to be heard at all?
City would ask the court to adopt DSHS's recommendations or findings.
Does defense want to be heard at all?
Yes.
Your Honor, we also ask the court to enter this finding, and we also ask the court to withdraw the assigned attorney due to breakdown of attorney-client relationship.
Yeah. And I would like to be heard on the record as well.
The court does adopt the report that was filed by
What does the report say?
DSHS finding competency in
Competent.
this case.
Is it uncomfortable? Okay, cool. Sweet.
That was by Western, right?
Yes, sir.
I'll check that box.
So now, can I go through a full phoretic colloquy so that then I represent myself and you are no longer... Okay.
We're not going to do that today, though.
Well, I'd like to do that because I'd like to, not have the public defenders involved anymore in obstructing, my rights. And then two, I need...
Seems certain to the court that you need legal representation, so I'm not going to do that motion today.
No, I don't, because
well,
can you answer this for me? I did a motion to revise the original anti-harassment protection order, and 4 or 5 different judges recused themselves on that. Are you aware of that motion to revise?
That's not before the court here today.
No, but it's really relevant, right? Because there's no probable cause to arrest me and hold me for this charge.
Found Mr. Spidell, so.
Then it hasn't been presented to me. I haven't seen any probable cause affidavit or anything like that. And if you read the motion to revise the original anti-harassment protection order, you'd see that there was no evidence in that hearing of harassment. All I did was try to let the prosecutor's office know of Brady Giglio material committed by Crystal Chapel, right? Can you let me speak, please?
You're being recorded.
Yes, I want this to be recorded.
You're being recorded and you're making admissions that might be against your personal interest in this case.
No, that's not true because I'm 100. I want the truth to be known. I have nothing to hide. Okay, so
we are.
So you guys are obstructing, though. You guys are doing the obstruction here, okay? So I want this to be heard on the record that I've just reached out to the prosecutor's office to let them know about Brady Giglio material committed by Crystal Chapel, and I was concerned that maybe she would be involved in high-profile cases like the cop that I heard was killed, and I would hate to see anything overturned once this comes down the pipe.
I'm sure the court would just hate to hear you throw around claims of Brady violations in hopes of getting your conviction overturned. But honestly, the more you talk, the more it sounds like you already know you're guilty and are desperately searching for a technical escape hatch. And considering this is a protection order violation, one of the more straightforward cases for prosecutors to prove you're not exactly making the strong, innocent person argument you seem to think you are.
On your case and not these.
No, yeah, this is my case, right? I've been sitting here in jail for 60 days without probable cause.
Probable cause is already determined, sir. So you are not sitting.
It's not a smiling matter. No, then tell me what the probable cause was.
Heard in this case.
City would ask to set for trial, Your Honor.
We're setting the matter for trial.
Okay. Then, ma'am, I think that you're outstepping your bounds and you're obstructing justice here. Because if you read that motion to revise the protection order, why have 4 different judges recuse themselves? Why did the gentleman just before you just recuse himself? You know, everybody's playing hot potato with accountability, but you're the only one who seems that.
And I'm not recusing.
You want to break the law.
Here I am.
Right, but you're not hearing me.
Oh, I am hearing you, sir. And what you're saying doesn't fit with the facts of the case. There was probably.
Then what are the facts?
And we're moving forward with trial. You'll get your trial on the merits, sir.
Okay, but I know that you guys are just going to dismiss it before trial happens because you don't want a jury to hear about all your misconduct.
Well, I don't mind the jury hearing what you perceive as misconduct. If it's
okay. All right, then I'm looking forward to that.
If you let us have a moment, we'll set your trial date.
From my calculations, Mr. Speedle has been in. We have Speedy running from November 5th to December 8th when the order was entered for competency. And so after the competency was on today, we're running from, so it was 33 days. We're 33 days into Speedy trial. So I believe if we set by January 27th, 2026, we would be within the 60 days.
Okay.
So
no, that's not true because I was arrested on October 28th.
Let's see about officer.
Today's day 59. Or day 65, depending on how you look at it.
20th, we don't have a jury because of the holiday, and that complicates getting a jury. And the 13th
Shame on you.
Heard by a protest if it's set on the 13th. So we have the 6th and the 27th, which is pretty close to. You know, the 27th you said is within Speedy, so.
I believe so. I'm going by what the jail records say of 11/3 as the booking date.
Okay.
Well, I object, you guys. Didn't you guys swear oaths to uphold the Constitution? Aren't you supposed to protect my rights and not violate them? Why don't I get a speedy trial?
I'm certainly trying to protect your rights, sir.
Well, then why are you even taking me to trial without probable cause? That's malicious prosecution.
I can't keep answering the same issue about probable cause. It's already been determined.
Well, then can you read to me, for the record, what the probable cause is? Because all in my records, I just see it says warrant, and warrant is not probable cause.
And probable cause is determined before a warrant is issued in this court.
So explain to me then what the probable cause is, why I've been sitting in jail.
And if you would work with your attorney, you would have all of that information.
I am my attorney.
That might genuinely be the dumbest thing you've said so far. No, you are not magically your own attorney just because you decided to declare it out loud in court. The attorney standing next to you is still legally representing you, and that doesn't change until the judge either appoints new counsel or officially grants your request to represent yourself. Courtrooms don't operate on "I said so" logic, no matter how confidently you try to argue it.
So I'm working with you now. Tell me what the probable cause is for my arrest.
I'm not granted any motion where you're representing yourself, sir.
Okay, well, I don't understand how you can sleep at night with this kind of misconduct. I mean, like, you know, all your colleagues have you know, passed the buck around, you know, playing hot potato, recusing themselves. And you can't even tell me what the probable cause is. You just say that it's already been established. Well, that doesn't fly.
January 27th, 9 o'clock is your jury trial. Status. Do we set status on the Friday? On the Monday. Your status.
You're obviously not a Christian or a follower of Jesus Christ. I can tell that. And you're going to have to answer for this someday, ma'am. You will be judged.
January 26th at 8:30 in the morning for status. Readiness. January 12th, 8:30.
And what about you, Mr. Good? Where's my probable cause? Where's my discovery?
On the same dates. Correct. All right. Out of custody dates for those matters are the same, only at 1:30. I'll put a note in here for that.
Yeah, put that note in there.
Now, obviously the court wants Mr. Spidell to be represented through a jury trial.
No. I'm going to represent myself.
Only if the court allows it.
Okay, well that's not fair, and that's against my constitutional rights. Okay.
Well within
Yeah, you're holding me without probable cause, and then you're forcing me to have a public pretender who's not gonna uphold my rights, or is actually actively working against me.
I'm sure. If you're not willing to work with your current attorney, we can find a conflict counsel to assist you.
I want a speedy trial. I want to represent myself, and I want it today. Today is day 65 of my incarceration without probable cause. That's malicious prosecution, according to RCW 9.62.100.
But I can go through the colloquy, but we can have standby counsel at the very least.
No, well, yeah, I'll do standby counsel, but I want the phoretic colloquy, so I'm representing myself, so that then I can contact the prosecutor directly from the jail. I can get my discovery and everything like that.
It would be, I think, against his personal benefit to be
This isn't a joke, ma'am. Why are you laughing?
legal representation. You know, to present yourself in front of a jury the way you're presenting yourself in court would not be to your benefit. And you
I beg to differ.
No, you're not some seasoned attorney handling hundreds of cases a year. You're just another guy who convinced himself he knows more than judges, lawyers, and the entire legal system combined. And now, allegedly, you thought it was a brilliant idea to modify your own protection order instead of going through the proper legal process? That's not legal expertise. That's the kind of decision making that turns a bad situation into a criminal case.
Sure you do. So, if we do go to trial on January 27th, which it's set for, I would encourage you to, at the very least, have standby counsel to assist you.
Okay. Yes.
So we'll try and find conflict counsel and in short order, so that you can speak with an attorney about your jury trial, which is coming up now.
Okay, but in the meantime, I would like Mr. Good to provide me with my discovery and the probable cause affidavit, and also a copy of my motion to revise the original anti-harassment protection order.
That's not
Thank you.
for this court. That's a different court.
Ma'am, this is a kangaroo court then.
All right.
You should be ashamed of yourself.
Your opinion.
Be that as it may, yep.
The discovery has been provided, and if you would work with your attorney, you would know all.
I am my attorney, ma'am.
You would know all that.
I want to work with the prosecutor because I'm representing myself. Okay?
Not at this moment. We are going to find you conflict counsel to assist you with the case.
No, I object. I object to that.
No,
I am fully competent enough, just like the 1077 found, right? That I'm competent enough to stand trial by myself.
Just because the court found you competent to stand trial doesn't automatically mean they believe you're competent enough to represent yourself. Those are two completely different legal standards. And whether you like it or not, the court stepping in on that issue is actually meant to protect your Sixth Amendment to the United States Constitution rights, not violate them. Because judging by the arguments you've been making so far, representing yourself would probably turn this trial into an even bigger disaster than it already is.
So if we are going to go through that colloquy and allow Mr. Spidell to represent himself with standby counsel, hopefully,
Yes,
I can do that now. So we can
yes, please.
Yes, Your Honor.
Thank you, God. Thank you.
Okay, you have the constitutional right to represent yourself if you choose to do so. It must be knowing and voluntary. And I'm going to make clear on the record this colloquy that you wish to waive your right to represent yourself and that you're fully aware of the hazards that you may face and the disadvantages of self-representation. Do you understand that if you cannot afford to pay for an attorney, can only partially pay, that, and you have been deemed eligible at this point, that you can have conflict counsel take over this case with you?
I understand that I can request counsel, but I don't waive any rights, especially my right to a speedy trial, and I wish to represent myself.
The only way we're going to get through this colloquy and help me make a determination that you can represent yourself is if you answer the questions specifically.
Okay, then can you repeat the question?
I can, yes. Do you understand that you have been deemed eligible for a public defender? If you wish to, we can find conflict counsel to assist and take over the case with you.
Yes.
Have you ever studied law?
I have studied law, yes.
Have you ever represented yourself or any other defendant in a criminal action?
Yes, I have represented myself.
And have you ever, or do you know that you're charged at this time with the anti-harassment protection order violation, 2 counts on this case?
Yes.
You understand the charge? Okay. Do you know that if you're found guilty of these charges, that you could be sentenced up to, these are gross, right? 364 days in jail and a $5,000 maximum fine on each count?
Yes.
Do you know that if you represent yourself, you're on your own unless there's standby counsel, and that the court cannot tell you how you should try your case or even advise you on how to try your case?
Yes.
Do you understand that you have the right to have your guilt or innocence decided by a jury?
Yes.
You understand a jury consists of 6 people chosen from the community?
Yes.
Are you familiar with the rules of evidence?
No.
Do you know that the rules of evidence govern what evidence may or may not be introduced at trial? And if representing yourself, you must abide by these rules of evidence.
Yes.
Are you familiar with the rules of criminal procedure?
No.
These are rules that govern the way in which a criminal action is tried in this court. Do you understand that?
Yes.
And do you know that if you decide to take the witness stand, you must present your testimony by asking questions of yourself, and you cannot just take the stand and tell a story, your story?
Yes.
You understand you must proceed question by question through your testimony if you choose to testify?
Yes.
Why don't you want an attorney to assist?
because they're not working for me, they're working against me.
Refusing to let a qualified attorney question witnesses and present arguments that could actually help your case is basically the textbook definition of sabotaging yourself in court. A good lawyer knows how to challenge testimony, object at the right moments, and keep you from digging your own grave with every sentence. At this point, though, I'm honestly hoping the jury trial gets streamed, because watching this guy try to represent himself and practically cross-examine his own credibility in real time would be absolute courtroom chaos.
Okay. Have there been any threats or promises that have been made to induce you to waive your right to counsel?
No threats or promises.
Do you realize that if you proceed without an attorney and you do not properly present a defense, subpoena witnesses, or otherwise represent yourself in a competent manner, that you will not be able to obtain a reversal of a conviction on the grounds that you received ineffective representation?
Yes, I'm aware.
All right. Then, again, the court would advise that you would be far better served by a trained attorney than you can be by yourself. You've already indicated that you're not familiar with the rules of evidence or criminal procedure. And the court would, again, strongly urge you not to try to represent yourself. But also, in light of the penalty that you might suffer if you're found guilty of 2 charges, and the difficulties of representing yourself, is it still your desire to represent yourself and give up your right to be represented by a trained attorney?
Yes.
Is this decision entirely voluntary on your part?
Yes.
The court finds that you have knowingly and voluntarily waived your right to counsel, and you are permitted to represent yourself. However, given your lack of knowledge of the rules of evidence and criminal procedure, the court is going to assign standby counsel to assist you in this trial, and would encourage you to work with this counsel so that you can present your case in a proper fashion and according to the rules of evidence and criminal procedure. So we will attempt to find conflict counsel to assist you with the trial. There's a lot involved in preparing. You've indicated that you've represented yourself in the past. I'm not sure which case that would be when I'm looking at your criminal history, but in any case, you've indicated that to the court. So I have factored that into the determination that you can represent yourself. So as soon as we can find conflict counsel, we'll advise them to get in contact with you so they can assist you in the preparation of the case.
Okay, well, in the meantime, all the real assistance I would need is just a copy of the court rules.
Okay.
So if I could get that in, then I could study them, and I wouldn't need any assistance from an attorney at all.
Oh yeah, because spending a month in jail obviously gives you enough time to master the mountain of legal procedures and courtroom rules that attorneys spend years studying in law school and practicing in real cases. Reading a few legal documents behind bars doesn't suddenly turn someone into a skilled trial lawyer. If anything, it usually just gives people enough confidence to make catastrophic mistakes while thinking they're the smartest person in the courtroom.
Okay. We will see what we can do about that. Is there anything else from the city's perspective that needs to be placed on the record today?
No, Your Honor.
And counsel or Mr. Spidell, anything else that you'd like to that hasn't already been placed on the record that you would like to have placed on the record today?
Just the fact that I'm still waiting on discovery. So if Mr. Good can please, get that to me in my cell, and also copy of the probable cause affidavit by any deputies working the case. And also I require a copy of my motion to revise the original protection order.
Again, that's not a matter before this court. We don't have jurisdiction on the original order.
No, well, I'm asking the court.
The one in this court.
Yeah, I did a motion to revise prior to my arrest.
The other orders are out of different jurisdictions. So that's
No, I did a motion to revise the protection order.
Whatcom County Superior. So the only one that we have jurisdiction over is the one that was entered in this court. So if that's what you're referencing, then we can certainly address that at some point.
Okay,
Discovery's
thank you.
already been provided. Did you want previous counsel to provide that to conflict, and
Yes.
it would have to be, reviewed for redaction and such?
Yes, sir.
Okay. All right, we'll get the materials that we can to you and to conflict counsel once we have conflict counsel on board.
Well, in the meantime, I would like it to me, because I don't require conflict counsel, so I don't want that to hold up, me getting my hands on these documents.
We'll see what we can do. The court's closed tomorrow, just so you're aware.
Okay, but did my former attorney here, do they have the discovery and everything? So can't they just provide it to me?
As long as
And so long as it's properly redacted, they should be able to
Yeah.
provide it.
the previous
Okay.
counsel should
Can you
be able
provide that to me?
provide that, but counsel, you need to review for any appropriate redaction pursuant
Okay.
to the law.
You understand?
Yeah, I can.
Okay.
All right.
Okay.
Thank you, Mr. Spidell. Thank you, counsel. Thank you, Mr. Good.
Thank you, ma'am.
And then we're
You
going to
need to
switch
sign
to
here.
judicial office.
I'm not
again.
Oh, this is a set for trial.
Well, I need to read it over before I sign it. So
All you're signing for is the dates
For
there.
the memories into.
Signing for the dates there, and also to abide by the previously imposed conditions of release. If bail.
yeah, I don't agree. I object to the dates, because I want a speedy trial within 60 days. So I'm not going to sign that unless it's under duress.
Just, it's fine. You have notice of the dates.
No, it's not fine. So I'm not going to sign anything at this moment. Sorry.
For you not to sign. Counsel, if you want to put in there refuse to sign, that's fine too.
Yeah.
Okay.
Thank you.
Thank you, man. Have a good day.
It's been a while since I've pulled out that clip, but honestly, this guy earned every second of it. And like I said earlier, I'm really hoping they decide to stream his jury trial, especially after they skipped broadcasting his pre-trial readiness hearing last week. Because if the hearing was anything like what we saw today, the actual trial is going to be an absolute train wreck in the best possible way. And trust me, if that stream goes live, I'll be covering every ridiculous moment for you guys. So if you enjoyed the video, make sure to leave a like, subscribe to the channel for more courtroom chaos, and hit the notification bell so you don't miss the next disaster waiting to unfold.